Types of contracts. What are the different types we have? How can you classify in general? If all the essentials are there, valid, else we can say as void or void ab initio, unenforceable. You remember when it will be unenforceable? Yes, please try to recall. When a contract will be unenforceable? Yes, please. Just try to recall all the 10 essentials. Okay. Tell me when a contract will be unenforceable. When a contract will be unenforceable. Yes, please. Sorry. No, no, no. Only in one situation it will be unenforceable. When? Let's just go through. No issues. Go through. Under the types of contracts in the very first heading. Yeah. If the legal formalities is not there, okay, you cannot say it's illegal. If I'm not stamping the documents properly, if one of the enclosures are not annexed in the application form, they're not rejected. See, illegal means different. Legal formalities means as per the law you have to follow, as per the act you have to follow. And if you're not following as per the act, what it happens? It cannot be executed. It cannot be enforceable. In that sense, you'll call here as unenforceable. So legal formalities has to be present. Okay, should not forget this one. Please take a note of this. And one more contract is voidable. Remember? Voidable. I ask you to read this as, yeah, please join. Avoidable, which means actually while entering the other's point of view, it will look valid. But if the aggrieved party or affected party wants to close it, which means wants to avoid it, then he can avoid it. That's why we say voidable. Can you get that phrase? Voidable from the types of contract. Voidable, yes, please join. From the material. Under types of contracts, go for voidable. There'll be one phrase, voidable at the option of one party. Which party will be that one party? Usually who will start? The aggrieved party. The affected party will start. Is it okay? Fine. So today's heading is on this one. Voidable agreements or voidable contracts. When a contract will be valid, the concern should be, what do you mean by concern? Acceptance. The concern should be free and genuine. Under 5 cases, we say the concern will not be genuine. Under 5 cases, 1, 2, 3, 4, and 5. The concern will not be free. Okay. No free consent. Under 5 cases. First one, coercion. Can you turn to that heading, please? Today's heading is on this topic, 2.4, free consent. Can you turn to the heading? What's the first one? Coercion. Okay. Please join with me. What's the second heading? Undue influence. Join for the third heading. Fraud. Fourth heading. Misrepresentation. And fifth one, mistake. Under mistake, if we go through, again, we can do a small chart work here. Okay, how it can be classified. Please make a note of all these 5 headings, where the first, second, third, and fourth case will be considering the agreement as voidable in nature, whereas the fifth case, we are going to say this is as void itself. Okay, to say in particular void ab initio. Okay. So first 4 cases will be falling under voidable contract. So today's heading is on voidable contract. Shall I take over? Okay. Actually, you can have like a chart work. Under the 5 phases, no free concern will be there, which means in some situation you might have been compelled to enter into this contract. So, first case, coercion. Coerce, the normal English dictionary meaning means threatening, பயம்படுத்துறது, threatening. Second situation, undue influence. Okay, undue influence, where somebody is influencing you. Okay, that may be your parents, that may be your teachers, that may be some close friend of yours. That person may be a mentor, that person may be a doctor, that person may be a professional. He says, and no other go because of the respect you have, because of influencing power they have, you oblige to them, which means you listen to them. Okay, that is what you call as influence. But what the law says here is influence is not bad, but what type of influence should not be there? Undue influence, which means you should not, the other person should not have a unfair advantage. What do you mean by unfair advantage? Means, see, if we enter into the contract, there is consideration which says that both of the parties should be benefited. But what happens here is only one party will get benefit and another party will not get the benefits, which means they are getting not equal advantage. They are getting unfair advantage. That advantage is not fair. Advantage means you can put it in brackets. It's about talking about benefits, the consideration. One party is getting consideration, other party is not getting consideration. This is a second category. Third category, actually, you can make this as single grouping. This one and this one, you can take it as one grouping. Okay. Third category, fraud. And fourth category, misrepresentation. If knowingly I hide anything and I make you to enter into the contract, we'll call it as fraud. Knowingly I do it. Okay. If it's done, but I'm not having any knowledge on this, unknowingly, it's called as see, you can break this word, right? Misrepresented. Misrepresentation. My intention is not that in such a way you should enter into my contract. The circumstances made in such a way that I did not know how, or I did not have the knowledge, and I made into you to enter into the contract. But what happens in the case of fraud? I clearly know, see, myself, Y, your X, I'm asking that we'll start a business. Okay, we'll start a new business. What happens is in this business, there is some smuggling involved. If I tell you what you do, okay, ma'am, double panada paakalam. Will you say this way or, ma'am, please don't involve me in this case? They're both happening. First case, what you're saying, yes, we'll do together. Then happily we both will start. Okay, equal share. What happens in the second case? Ma'am, please don't involve me in this case. Okay, genuine etc., etc. So actually, if I tell the full content, what you do? Definitely will not accept, so I hide. Saying that this is accepted in India, you can do it. Okay, I'll not say that this all smuggling activity is going to happen. Probably I'll give you a truck and you have to travel in the truck and you have to deliver the goods to me. That's it. So all the smuggling activities, if hidden, which means if I tell that to you, it is known as I'm hiding it. It is known as intentionally done. If it is intentionally done, we call it as a fraud. If it is intentionally done, we call it as a fraud. Okay, so that's about this case. Intentionally or knowingly done. If I myself don't know, okay, then it will be called as misrepresentation. I can put this under second group. Okay, fraud and misrepresentation. Then I have the fifth case or the separate group, which is called for mistake. Under mistake, we have two types of mistake. Probably I'll deal this concept a bit earlier because only the first four cases falls under voidable case. Other the mistake falls under void ab initio. Okay, so I'm going to deal the first four cases as of now immediately. Okay, so you can join from Singer material. Yes, please. Concerned. Usually the heading given here is free concern. Concern should be free and genuine, free consent. Okay, once again, free consent. How the consent should be normally, not only free, it should be genuine. See, I'm telling that this business involves some smuggling activities. What you do? Immediately you say you're not interested in involving. What I do is, in that agreement, both the parties have to sign. I put my signature and also I put your signature, which means what I'm doing? Forgery. Forging the signature. This should not be done. See, you know that you haven't entered into this contract. I know you haven't entered into this contract. What about the third party outsider? How the third party will look this contract? Whose signature is here? Mine. Whose signature is there? Yours. So how the law is taken here? It is taken as a valid contract. This is what you call as forgery, and forgery also you will not say it's a free consent. So general heading is free consent, but if you go internally, you can find free consent and also it should be a genuine consent. What are the 5 cases which are not a free consent? Yes, please join with me. Coercion, undue influence, fraud. Fraud is different from forgery. Okay. And misrepresentation and mistake. So I'm just dealing with this 4 cases first. Coercion. Please join with me. This is the definition. Committing. I'm threatening you. Okay. How? I threaten you or I threaten to commit you. Probably by a forbidden act under Indian Penal Code 1860. Probably I'll put a gunpoint and I show that I'll not shoot you. I'll show a gunpoint saying that you have to enter into the contract. If you're not entering, over. ஒரு பெரிய அருவாள் எடுத்துட்டு வரேன் வெட்டிடுவேன்னு சொல்றேன் வெட்டணும்னு அவசியம் இல்லை இல்ல கையை வெட்டலாம் விரல வெட்டலாம் ஓகே it happens to be a committed one which means what done already and no other go you have to sign in it or what I'll threaten you that I'll cut your hands I'll shoot at gunpoint. Either it can be committed or it will be threatening to commit. Both if it is forbidden by Indian Penal Code. Okay. What Indian Penal Code says is, IPC says is, what IPCC says is, if it is forbidden as per Indian Penal Code, then you say it's a coercive. What's the normal English definition? What's the normal English definition? What does coercion means? Normal English definition. You can please write it side. What is the English definition of coercion? Which means just threatening. What is the legal definition as per Indian Contract Act? What do you mean by coercion here? Threatening, but not all acts are considered as threatening. You have to refer Indian Penal Code. Is it okay? Not only doing some act regarding to that particular person, it may be unlawful detaining or threatening to detain any property also. So it's in 2 angles. One is the concerned person and another one is the property also. Okay. What do you mean by property? My daughter is my property. You agree with me? My son is my property. Okay. Your property for your parents. If your dad has to enter into a contract, okay, the other party is not pointing the gun at your father. He's pointing the gun at you. Automatically your dad signs. So what happens here? Any property means is not like tangible or intangible in nature. Generally, we say property means the estates and heirs. Okay. So with the intention, what's the intention behind this? To enter into an agreement. It can be against the contractual parties or any other related person. Can you go for the examples, please? We have 2 examples. Yes, please. You can go for first and second example. Can you find a point over there? It need not be adequate. It need not be adequate. Which point is there? Can you tell me the point number? I'm not going to tell you. Huh? No, I'm asking which point, not page number. Fourth point. Okay. Fourth point under legal rules or legal validity for a consideration to be a valid one. Okay. What that point says? Yeah. What that point says? Consideration need not be Adequate. Okay. Need not be adequate. Adequate. Okay. What this case says pa here. First one. X threatens to kill Y. For what reason? If he does not agree to sell his car to X for 10,000 rupees. See, you're in which world that a car is being sold just for 10,000 rupees? See, why I have to sell the car just for 10,000 rupees to you? Because you're threatening me, right? But for the outsider, for a third party, because this person has threatened this person to sell the car, probably this person has sold and signed the agreement. For the third party, how it will look? It will look like a valid contract. You will not call this as agreement. You will call it as valid contract itself. Because uh, sorry, seeing from the outside view, you will find that offer is there, acceptance is there, etc., etc. But now this person who's X or Y, now Y wants to avoid this contract. We call this as voidable contract. Wants to avoid this contract. What he will do? He will go to the court of law, right? This is going to happen. He will go to the court of law. When we say it's voidable, we use this phrase. You remember? Voidable. Yes, please join. Voidable. Yeah. At the option of one party. Who is that one party here? Who is the affected party? Y. Because X has threatened to kill Y. Y is the affected party. Y is that one party. This one party can go to the court of law. Okay. What he'll go and say to the judge, not directly to the judge, through the advocate. What he'll go and say, I'm being coerced. Okay. And what will happen here? He has to prove. Who? Y has to prove that he has been threatened so that no other boy has to sign the document. Okay, who has to prove this? Y has to prove. What will Y will say? ஒரு 10 ஆளுங்களை கூட்டிட்டு வந்தாங்க. ஓகே, என்ன பண்றதுன்னு தெரியல. ஒருத்தர் கட்டை வச்சிருந்தாரு, ஒருத்தர் அருவா வச்சிருந்தாரு, ஒரு கண்ணை வச்சிருந்தாரு. என்ன பண்றதுன்னு தெரியல. Automatically, I signed. This is how it will start. Okay. See, myself X. Silent இருப்பேனா? I did not do all this, sir. I just went, asked for this. He said, okay, he'll sell it for 10,000 rupees, and I signed. That's it. I did not take anybody. I'm not there in the station also. I just went for a phone call. I asked whether he's willing to sell for 10,000 rupees. He sold the car. That's it over. Now, he might have discussed, that is myself. I might have discussed in this way. So, what the court will say? Consent is free only, contract is valid. Okay, if myself X, I'm not able to prove this one, automatically this becomes a what contract? You'll not say voidable, you'll say it's becoming void. See, till you prove this is valid or void, it will be called as voidable in nature. Okay, voidable in the sense that you can avoid it in the future. But before proving that, it will look like a normal valid contract. See why I took this point, this earlier point. This one need not be adequate. So this one 10,000 rupees for selling the car just for a very nominal amount will be helpful for Y to prove that he is being coerced because it is not adequate. Can you again refer to that point below that you have found? You can find some line saying that the court will ask for the free consent. It is over there. Please check. It is over there. Yeah. You can please highlight these 2 points over here. You can put or you can refer the page number. You can put it over here. Like to take over? I'll go for the second case. A tells his wife that he would commit suicide. Why and when? If she did not transfer her personal assets to him. Okay. She does so under this threat. No other go to save his husband's life. What she is doing? She is transferring all the personal assets to him. Can the wife avoid the contract? Yes, she can avoid because it's happening under a threat. What is the threat here? Committing suicide. He did not commit suicide. See, now go for the definition. Committing or threatening to commit. Not committed, but what? Threatening to commit. Okay, this also will be considered as coercion. Follows from definition of Indian Contract Act. Okay, so we can refer this case, Sheshama case. Yeah, the first one, we need to check. See, when we talk about coercion, we are checking with the definition of Indian Penal Code. Threatening is with respect to the definition of Indian Penal Code. But this Indian Penal Code should be in force. Let us check with this example. Can you go for this example, Pa? Yes, please. A. Onboarding an English ship on the high seas. What do you mean by English ship? It is not a Indian ship. Okay. A. Onboarding on English ship on high seas causes B to enter into an agreement by an act amount to criminal intimidation under IPC, probably showing a gunpoint or maybe some other act, maybe saying that if you don't sign the agreement, I'll push you down the sea. That also a threatening act, right? கடல்ல தள்ளி விட்டுருவேன். That's also a threatening act. Okay. So this is the case happening. This is the situation happened. A afterwards, okay, he signed. It is now a valid agreement. Looks like a valid agreement. A afterward sues B for what? For breach of contract. Where? At Calcutta. See, this case you have to link geographically. Where this agreement is being entered into in an English ship. How you say the ship is an English ship? See, there'll be some flags on the ship, right? If it is an Indian ship, you can find an Indian flag. If it is a non-Indian ship, you'll find other flags. So yeah, if you're having a UK, what, England, that's what you call as the English ship. Okay. Our heading is whether Indian Penal Code should be in force in that place. Okay, whether Indian Penal Code should be in force, which is Indian Penal Code is meant for Indians. Okay. Is this applicable for English ship? That's the question over here. Let us check. A afterwards sues B for breach of contract at where which place? Calcutta. Here, A has employed coercion, although his act is not an offence by the law of England, because it's an English ship. Indian Penal Code is not applicable for England. Okay. And although Section 506 of the Indian Penal Code was not in force at the time when and where the place was the act is done, here we call it as coercion only. Please try to understand. Read it once again. I'll explain it again. Read it once again. Please carefully understand. What's the second point here? Restitution is applicable for voidable contracts. Yes. What do you mean by restitution? Remember, we were referring so many R terms, and one R term is restitution. Restitution is not applicable for uh, agreements with minors, but whereas when you go for voidable contracts, restitution is applicable. In case in this contract, A has got some benefit. Okay, A has got some benefit, and we clearly say here it is a voidable contract. And when the court says so, then A definitely has to return the benefit. So 2 points. First one, it should be voidable or void contract, not agreement, void contract. It should be either a voidable contract or void contract. First point. And the other party should have got some benefits because of this contract. If these two conditions are satisfied, then the party has to return the benefit. Return the benefit. This is what you call as restitution. If you want, you can please make a note of it. This is what you call as restitution. Okay. Shall I take over? Second heading, undue influence. Please try to consider this as two words. One is normal influencing, but the heading here is about not about normal influencing, but about what? Unfair advantage of normal influencing, which means gaining unfair gaining unfair advantage. Because you're having some trust or confidence on somebody else, and you're exploiting that. What do you mean by exploiting? Taking in a bad intention, bad manner. Either this may be a situation, or you're trying to dominate, that may be the situation. Under both the cases, if one person is getting unfair or unfair advantage, we'll call this as undue influence. Let me go for the example. A's son has forged B's name to a promissory note. B, under the threat of prosecuting A's son, obtains a bond from A for the amount of the forged note. If B sues on the bond, the court may set the bond aside, which may say that it will not be applicable. You can say non-applicable. If you're okay with this case, means you just make a note of it. If you're not okay, we will go for referring Negotiable Instrument Act and we'll come back. Okay, you need not worry as of now. Okay, because you need to have the knowledge of negotiable instruments, bill of exchange, a promissory note, and all. So that's why I just keep this pending. I'll make a star mark. Under which cases you may be dominated? See, the second point here is about what? Who will dominate you? There should be some authority, right? Your manager will be dominating you. Your parents will be dominating you. Okay, the one who's very close to you will be dominating you. So usually who will dominate? They should have some deemed position. What position? Real or parent authority? Probably like employer and employee. Employer and employee. Which means what? He is given proper authority. If he says anything, you have to do it. Okay. Fiduciary relation. What do you mean by fiduciary relation? Probably directors of a company. They'll be having fiduciary relation because company being an artificial person, it doesn't know what to do. What are all the directors say, it will do it. Fiduciary means உங்களை அப்படியே நம்ம நம்புறோம். நீங்க என்ன சொல்றீங்களோ அப்படியே நாங்க பண்ணுவோம். That's what they call as fiduciary. For a company point of view, its fiduciary relationship is there for directors and company. So directors and company. So first case, second case, and third one. You're mentally not fit. Okay. Probably that may be temporarily or permanently, mainly because of age or because of some body illness or some mental or body distress. Because of this, if your mental capacity is not strong, then automatically you will be dominated by some other person. Who will be that some other person? A doctor, a caretaker, a nurse. So they will be telling something to you and you say okay for everything. You are in such a situation. Okay, so under these three conditions, we say that the authority is having a dominant position, which means deemed position. Is it okay? First one. Second, unconscionable bargains, which is happening in a money lending transaction and in gifts. See, you might just recall from your young age, you know, any one relative of yours always gives gifts for your birthday, whenever you go visit their home, at least chocolates or cash or money or something. You know any other person of this type? Mama, atta, very close, grandmas, grandpas. Whenever you go, they'll give some sweet. They'll give some toy. They'll give some small amount of cash. They'll give chocolates. So next time when you go, you have that expectation. What expectation? Definitely you get something from them. That may be a close friend of yours. That is your parents' friend or anything like that. That may be close relative of yours. So automatically, what your mind does here is, if he says anything for you to do, you will do it. Okay. எப்போ பார்த்தாலும் சாக்லேட் ஸ்வீட்ஸ் கேஷ் கொடுத்துட்டே இருக்கிறாரு. வாட் யூ டூ நவ்? ஓகே, அவர் நம்மளுக்கு என்னமோ கொடுக்குறாரு, அவருக்காக ஒண்ணு பண்ணுவோம். So if that is done, it is called as influence, and he is asking you to do some action, and you do it. What action? Don't take it personally. Probably he says that I'll give you a cycle. Okay, you know to ride a cycle. I'll give you a cycle. You just deliver the cycle to this destination, to this person. And he's giving, all the time he's giving you with sweets and other things. மாமா சொல்லிட்டாரு பண்ணிடலாம் அப்படின்னு சொல்லிட்டு என்ன பண்றீங்க? You are going to deliver the cycle. And this cycle is not your uncle's. Whose cycle? It is a theft. Okay. You'll be worried about this one. You don't know. You know or need not know. That doesn't matter. What is the influencing capacity he has here? Not just because of relative, but what he is doing here. He is creating some situation so that you listen to him. First thing. Okay. Second thing, and this has been completely hidden. Why he is hiding from you? Because it's not his own cycle. Okay. Why you do it? Why you do it? Because you got some gifts. Because you got some loan from him. Now come for this point. Unconscionable bargains, which means one person will be benefited, other person will not be benefited. So this happens in case of money lending transaction. So this case law, Kriparam, he is a youth who has completed 18 years of age, spendthrift and a drunkard, borrowed how much? 90,000 on a bond bearing compound interest of 2% per month, not per annum. If it is per annum means 2% is a very small amount. But what happens? 2% per month, and it's not a normal interest. What type of interest is this? Compound interest. You know about compounding, right? Every month this 2% will be added and from that amount it will be charged. So compound interest. It was held by the court that the transaction is unconscionable. Why? Because the rate of interest is being so exorbitantly charged. Now comes a discussion where you can say or under which relationship you can say undue influence may arise. Okay, there. See, a parent is there and the child has to listen to the parent's wording. No other go. You call this as influence or undue influence? We call this as influence. What's the heading here is undue influence may arise in this case. So if a case is taken to a court, what the court will check, what type of a relationship is this one? If it falls any one among this case, then it will check whether it's undue influence. So it's a two-step process. They'll check whether it's an influence is there. Second step, they'll check whether it's undue influence is there. Okay. So where it happens, parent and child relationship. Second, guardian and ward. Third, master and servant. Fourth, trustee and beneficiary. Fifth one, doctor says, patient no the go listens. Religious guru and disciple. Income tax officer in relation to an assessee. Magistrate or police officer in relation to an accused person. Ninth one, financer and financing. And tenth one, solicitor and client. Solicitor means advocate. Advocate and client. In all these 10 relationships, usually the court considers there may be an undue influence. Okay, there may be an undue influence. Let me go for this example. A having advanced money to his son, B during his minority, and upon B's coming of age, obtains plus misuse of parental influence. Please highlight misuse of parental influence. Okay, see what type of relationship is over here? Parent and child. Okay, a bond from B for a greater amount than the sum due in respect of the advance was taking here. A employs undue influence because he is a parent for the child and how much he was spending during this amount when he was minor. After becoming major, what he is doing? He is issuing a bond saying that this much amount I have spent on this case. Okay, so this is actually the relationship between the two persons, parent and child, and here we can say that he is influencing undue influence. Please make a note of this example. If you get this question, you have to write this one. Okay. CMA Inter CA Foundation, definitely you have to write some examples. You can take this as an example over here. CMA Foundation, you may get small questions as what? One word questions. Okay. Relationship where undue influence does not arise. Wherein undue influence does not arise. First one, landlord and tenant. Landlord and tenant. Okay. If the landlord says tenant has to listen, yes, obviously, you might have find in many houses. The ஆணி அடிக்கிறது ஒரு ஆணி ரெண்டு ஆணி தான் அடிக்கணும். Yes, he's the owner. He says you have to listen if you are a tenant. But if the landlord influences you on something particularly and you have to listen it, no, that is not an issue. You should not listen it. Okay, if you listen it, that's your personal. Losses is not an undue influence. Okay. If he coerces you, listen, that's different. We are talking about the influencing capacity, the authority. Okay. Creditor and debtor, no. Undue influence does not arise. So, first, second, please make a note of this third case, husband and wife relationship. I want to place a star mark over here. Usually, when we talk about husband and wife, two parties to a contract will not consider this as a contract at all. We know, right? But when this wife happens to be a Padmanasin woman, what do you mean by Padmanasin woman means she is secluded, being away from the people. She'll not be allowed to mingle with the other male members of the family, or she can mingle with the male members of the family, but not completely from the male outsiders. ஆம்பளைங்க கிட்ட பழகக்கூடாது, வீட்டை விட்டு வெளியே போகக்கூடாது, யாருமே பேசக்கூடாது, அந்த மாதிரி எல்லாம் இன்னும் சில ஃபேமிலிஸ்ல இருக்கு. அந்த மாதிரி தான் we call it as பத்தனாசின் woman. Okay. Here is a case law, Ismail Muzaffar versus Hazibu case, who you cannot call a woman as Padanasin woman. So generally when we say Padanasin woman, she is completely relying on her husband only. She doesn't know anything what is happening in the outside world. So what she does, whatever her husband says, she listens. Okay, this is the status of Padanasin woman. But there is one lady, please make a note, there is one lady who goes to the court for filing a case. There is one lady who gives evidence for supporting a case. There's one lady who fixes the rent and collects rent with tenants. See, Padanasan woman is the one who is not going outside to the outside world, who's not having any word with the outside community. But what she does here in this case, she fixes, not only fixing up the rent. See, how you know? See, this is the locality, this is the square area of my property. Then I can fix this much as the amount. How we know all this? You need to have some basic thing, right? Where is the locality situated? It's in the main road. So you can fix rent and premium, right? Second point. This is somewhat a big house, 2,400 square feet property. Okay, what do you say? Oh, we can collect some 50,000 or 60,000 rupees. Okay. How do you know? How do you have this knowledge? Probably might be knowing the outside world, or somebody might have communicated to you. So there is one lady who she can fix the rent and collect the rent with the tenant means she's not a Padanasin woman. You agree with me? She is gaining or she's having knowledge with the outside world. So how can you say that lady is a Padanasin woman? You cannot see. So first one, going to court. The second, getting evidence, giving evidence. Third one, communicating with tenants. And fourth one, communicates the business matter with men other than the members of her own family. Please highlight. If she is communicating the business matters with the male members of her own family, means she is called as a Padanasin woman. But she is communicating with the outside members, means she is not called as a Padanasin woman. Okay, fine. So all these cases say the wife is not a Padanasin woman, then there exists no particular relationship between husband and wife. So no undue influence between husband and wife. If the wife happens to be a Padanasin woman, okay, come here. If the wife happens to be a Paradanasin woman, then what happens? Husband says everything and the wife listens. Obviously, here undue influence arises. Okay, please check whether you can manage this heading. Burden of proof. Who has to prove? You can have the heading written as who has to prove. Usually, who has to prove? The aggrieved party. Okay. If the aggrieved party, the other says the other party has done this coercion or this mistake, what the other party can do in order to save himself can counter prove. How he can counter prove? See, earlier case we were saying that, right? X kills or threatens to kills Y. Who has to prove? Y has to prove. Aggrieved party. If Y says myself X, I'll be saying yes. I only threatened Y to kill. No, I'll not agree, right? Because I'm a defender. I have the right to defend, so I'll not agree. So myself X, what I'll do? I said there's no strong relationship between me, X and Y. Because only when this is a strong relationship, some deemed position, I can say there's an influence. So there is no such influence. Not only that, I disclose all the material facts. Not only that, I ask that respective person to go and refer a doctor or to go and refer a lawyer to get extra competent advice. If this is a situation, then obviously who will be failing in this case? Why will be failing in this case? Okay. Go for the example, please. So example and case laws you can go through. A study on coercion or undue influence. Coercion by action, we call this as doing some physical force or giving us a threat like. Whereas if you go for undue influence, there'll be a moral or mental pressure. Criminal intimidation here goes with IPC 1908, whereas here it goes with no such cases and all. It can happen in any way. Relationship, no such relationship, but here you need to have some type of relationship, either husband and wife, or parent or child, or financer or financier, or creditor, or any type of relationship will be there. It can be exercised by a stranger also, but here no such stranger can be involved. He'll be somehow or the other connected with the other party. Okay. Position or benefits, restitution is there. Please highlight this fourth point, fifth point. In the case of coercion, you may be asking you to restitute it, but undue influence, you have to prove this is valid or void. If it becomes void, then it's a court only deciding it. So we call it as court's discretion to decide whether restitution can be given or not. Okay. So this first heading we are done with coercion and undue influence. Next, let me go. It's a third category. Yeah, please join. One is fraud, and the other one is misrepresentation. Am I right? Yes. What are the points we have to understand over here? When you talk about fraud, first point. Yes, you just directly go from here, from the material. It's a misstatement of a material fact. Okay. For fraud, what it is given? Not a misstatement. Yeah, please make a note of it. It's a, okay, actually I have written the other way. Not a misstatement. It's a misstatement. Yeah, next point. Second, here it is knowingly done. Now, here it is unknowingly done. Third one, here it is intentionally done. My intention is to to enter into the contract. Here it is unintentionally done. There is no intention to grab you into the contract. Okay. And fourth is the very important point. It is a criminal act. Please highlight it is a criminal act. But misrepresentation is not a criminal act. Is it okay? See, in single material, misrepresentation is there first, then fraud. But here I wrote the fraud heading first, okay? So you might not be directly matching with that. Yes, please join. Misrepresentation. The other heading where you can have for misrepresentation is innocent misrepresentation. Please highlight innocent way of entering or making you to enter into the contract. So there is no intentional thing to make you. So misstatement made innocently, no intention and not a criminal act. Let me go for this example. A, see it will be clearly stated as misrepresentation. Okay. Leads B erroneously to believe that 500 mons. What do you mean by mons? Means like visipam or mutta. Okay. So 1 mon means here it is 37 kg. To believe that 500 mons of indigo are made annually at A's factory. B examines the accounts of the factory, which show that only 400 mons of indigo has been made. After this, B buys the factory. The contract is not voidable because of this misrepresentation. Why? He had checked the accounts, right? What actually, while entering into the contract, he said anonymously saying that how many mons are being made? 500 mons. But actually checking the accounts, what number is showing? 400. So he cannot say that you made a misrepresentation. That's why I want to cancel the contract. He cannot do that because he has already checked the accounts, even though it's a misrepresentation. Types. Two types of misrepresentation are there. One is unwarranted statements, and another one is with respect to breach of duty. When you say unwarranted means you don't have any particular reliable source and all. You don't know how to believe whether it's positive or you can believe or not, whether it's absolute. You don't have any reliable source means you call this as unwarranted statement, which means what? If you say it's misrepresentation, then it's fine. We agree to it. Breach of duty means is actually it's like misleading only to bring some advantage to do it. Okay. Let me go for the example. X believed the engine of his motorcycle to be in excellent condition. See what they say here? Please highlight this word. See, if you go through the case law, it's easy. But my intention is when you see this word, you have to understand this is a misrepresentation. That's why I'm trying to highlight you. X believed the engine of his motorcycle to be in excellent condition. Pa. At the time of sale of this motorcycle, X, without checking it, without getting it checked in a workshop, told Y that the motorcycle was in excellent condition because he believed, right? See, I'm using my two-wheeler for the past 2 years and I have not faced any trouble till here. So what I think, it is in good condition. And I'm now about to sell my two-wheeler to you. Okay, so I'm telling that I'm using for 2 years. I have not faced any problem. It's in good condition only you can buy it. Which means, see, first word, I believed. And without checking, see, why I did not check? Not intentionally, I did not do it. Because to defraud you. I did not do in that way. I believe it is in excellent condition. So I did not check. So I'm not doing any fraud or something like that. Okay. On this statement, why bought the motorcycle whose engine could be defective later? It's an unwarranted source because there is no particular reliable source link. If I'm a mechanic, I have said that it's fine. I'm not a mechanic, but I believe and as a normal layman, I sold because it's unwarranted statement. There is no reliable source. So I can go for this case law. Okay. Breach of duty means, see, when you go for this mine restorations and all, you know about this uh, coal mine and gold mine, whatever the mine, iron, ignos and all. Whenever you go for mining, after mining, you have to restore the mine. You have heard of this concept? You have to restore the mine. You see, mining is not a normal job, right? You have to dig the hole in the earth. Amadana. You have to dig the hole. நல்ல பள்ளம் தோண்டுவாங்க. It will go like 100 feet to 200 feet depth. Cave will be done. The cave குள்ள போயிட்டு tunnel மாதிரி எல்லாம் பண்ணிட்டு உள்ள போயிட்டு you have to get what? Gold or coal or whatever it is. Once you have taken the gold and other ores out of that, what you have to do is you have to restore, which means what? பள்ளத்தை மூடணும். Okay. If you have entered into a contract means is understood for mining related contracts is understood it's a default clause where the restoration has to be done. So it is a gold mine case where you have not restored means actually you cannot rescind the contract. You call this as breach of duty, which means what? What do you mean by duty? Your promise you have not fulfilled. Okay. So this is about misrepresentation. Let me go for fraud. Then we were saying it is innocent misrepresentation. Here we say this as willful misrepresentation or what? False representation. Please highlight. Both the words are equally important. Please highlight. You can call this as fraud or willful representation, or you can call this as false representation. Is it okay? Actually, not a misstatement made willfully to deceive the intention of the other party to enter into the contract, and it's a criminal act. The next heading, please make a note of it. It's quite important. When you think that fraud will exist, without belief in its truth, probably we are not relaying whether it's right or not. Active concealment or knowingly having a belief of the fact. Okay, active concealment means what? வேணும்ட்டே நான் hide பண்றது. Active concealment. Concealing means hiding. Okay, suppressing, all the things will come here. No intention to perform. Okay, which means what? I'm not showing any positive act to do it. Okay, any act to deceive. See example. Silence is also fraud. If I ask you something, you have to reply to that. If you're not replying anything to that, what the law says is take it as fraud. Because it's your duty to explain the situation. Any fraudulent act or omission is also considered as fraud. So in this situation, fraud exists. Yes, I have to go for examples. How many examples are here? 5 examples. Yes, can you please go through all the 5 examples? Join for the second one. A man by the name of Sham called a jeweler's shop He went to a jeweler shop. Who? This person, Sham. He went to a jewelry shop and he chose a costly ring. Okay. He tendered in payment a check which he signed in the name of credit. He took the ring and pledged it to Bolanath. So he took the ring and pledging is type of a special contract covered under Indian Contract Act. So he went to Bolanath, okay, and he's pledging the ring. And this person had who? Bolanath had no notice of fraud. Can the jeweler recover the ring from Bolanath? Let me come again. A name, a man by the name of Sham called a jeweler shop and chose a costly ring. Just try to visualize this one. So you're one person, Sham. You're going to a jewelry shop and you're choosing a costly ring. Okay. And what you did then? You gave a payment in terms of credit. Okay. So it is done in a check. Then he took the ring. It's a credit purchase. He took the ring and he pledged it to Bolanath. This Bolanath, see, if you go for Adamana Vekkam, if you go for pledging a small jewel or something like that, what the other person has to check, what Bolanath has to check, whether he has to check whether it is Sham's property, Sham's goods. Bolanath did not have this notice of fraud, which means what? He thought that it is a Sham's property, Sham's goods, and he took it for pledging. Okay. Now, they're not asking about the status of Sham or Bolanath. The question is, can the jeweler recover the ring from Bolanath? The answer is no. The jeweler cannot recover the ring from Bolanath. Why? Because of this one single word, one single line, had no notice of fraud. I want to highlight this line. Because Bolanath, in good faith, which means what? No notice of fraud means what? In good faith. When you go for understanding law, there are so many principles we follow, and one such principle is principle of good faith. If I enter into a contract, see, pledging is nothing but a contract. When I enter into a contract, I need to have good faith on you. If I don't have a good faith, then there is some doubt on you, means I have to ask question, or I should not enter into a contract. Here, Bolanath had no such doubt or something, so he had no notice of the fraud, which means as per principle of good faith, it is said that it is a correct contract only. It's a valid contract only. On whom and whom? Sham and Bolanath. Okay. Now, who is recovering the jewel? Who is trying to recover the jewel from Bolanath? Jeweler. Who is the jeweler? Stranger to a contract. Stranger to a contract has the capacity to sue or recover the jewel. Has no rights, right? See, if you think that, ma'am, jeweler is the owner for the ring, ma'am. Okay. So he is the owner. So does not he have the right to recover from Bolanath? Means law says no. Because Bolanath has got this in good faith. So only the jeweler can recover from Sham only, not from Bolanath. Please highlight somewhere. There is a contract between Sham and jeweler. There is a contract between Sham and Bolanath. Here the jeweler becomes third party to the contract. Third party to the contract does not have the right to sue or recover the jewel. From whom he can recover it? From Sham. But Sham does not have the jewel with him now. He has given to Bolanath for pledging. So only thing the jeweler can do is ask for the price. Okay, ask for the price. It's a beautiful question, pa. Okay, please go through once again. If you're okay with second one now, then go for the third one. Yes, please. So what's the situation here? We'll compare with second one, okay? There it was Sham, okay? And who's the person here in the second case? A woman. Here there was nowhere used to saying that fraudulently, but here it says the woman fraudulently represented to the firm of jewelers that she was the wife of certain baron, okay, and obtained two pearl necklace on credit. There also credit, here also credit only, on some pretext with a view to buying them, okay. So the major difference is it's a fraud. Fraud means contract is not valid. Okay. She sold these two necklaces to X. Who is X? A third person. So jeweler, the woman wife, and somebody else X. In second case, it was jeweler, Sham, and Bolanath. Please make a note. The main difference here is one, they are clearly saying it's fraudulent case. Here they have not mentioned it's a fraudulent case, but according to Bolanath, he had no notice of the fraud. So I may take it as a fraud has taken place there, okay? Because he has taken in credit, but he has not made the payment. So nothing is mentioned about the payment. He has taken for credit only. Okay. And another one major difference is here the contract between S and B, Sham and Bolanath is special contract pledging. But what happens here, woman and X? It's a sale. And please tell me, whether can you say this as a sale? How you define a sale? Sale na another. How you define a sale? I own this laptop. I can sell it, which means what? I should be a owner first of all. So in this case, if you tell this is a sale, see she is selling those necklace to X third party. If you want to use the term sale means W should be the owner first of all. Is W the owner? She fraudulently represented that she was the wife of a baron and obtained these two pearl necklaces on credit and she goes away. Which means she has not got the clear ownership. So still, who is the owner for this jewels? Jeweler only. Okay. So can the jeweler recover the necklace from X? Yes, they can recover. Here, in this case, pledge is valid. In this case, sale is not valid. Because pledge is valid, jewelers cannot recover the ring from Bolanath. Here, sale is not valid. I'm in the third case. Sale is not valid. So, jewelers can recover the jewel from X. There it says we are following the principle of good faith. Here, who is the owner? His right has to be protected. Probably can make a note of it. Owner's right has to be protected. Owner's right has to be protected. Is it okay? Please make a note. Both are two different cases. Only thing there is pledge. Here is sale. Looks somewhat similar. Okay. In the third one, instead of the woman selling the pearl necklaces to X, if she keeps as for loan purpose, that is pledging, what would be the case? Go for sham piece. Whether that sham or wife of any baron, whatever it is, the main content is there, it's pledge, here it is sale. Please be aware of the two cases. It's very, very important, especially CMA students, interlevel. Okay, yeah, this is often asked question. CMA foundation. Silence and fraud, both same. If you are silent, it's not fraud, but there are some exceptional cases. First one, it is your duty over there to speak. If you're not speaking, then it is a fraud. Okay. See, X sold by auction to his brother, to his own brother, his old car, which X knew to have defective engine. Please try to understand. There are two parties here, X and his brother. He's selling by auction. Okay. Who's buying the car? His brother. X knew. Who's X? The owner of the car. He knew that he has a defective engine. X had nothing to worry about the defects in the car engine. This amounts to fraud as the relationship between X and Y makes X duty to tell his brother about the condition of the car engine. Even though brother and brother. Why? This is not happening brother and brother. Please try to understand. It's happening through an auction sale. It's not direct sale between brother and brother. It's happening as an auction sale. When you say auction sale, not only why one of his brother is present, along with why many were present and the bidding goes on and among the bidders why will be chosen. ஏல கேட்டாங்கல்ல ஏல விட்டாங்கல்ல கேட்டாங்கல்ல பிட் பண்ணாங்கல்ல அதெல்லாம் வந்து வையோட சேர்த்து மிச்சவங்களும் இருந்தாங்கல்ல. Is it okay? So we'll go for two categories. Just you can take it for noted. Fiduciary relationship and iberi federme. Please highlight this. It's a legal maxim which says whenever you go for this auction sale and other things and all, you have to go for disclosing all the material facts. So significant matters. Fiduciary relationship means because of confidence it comes and you have to disclose all the material facts. You can go through this case law a bit later and just going for the next heading. Second one. What was the first one? It is a duty. You have to speak. First one. Second one. If you are not speaking, it is considered as, that is, if you are silent, it is considered as you're accepting, which means your speech is there. Example, B says to A, please try to understand. B says to A, if you do not deny it, I shall assume that the horse is sound minded. Okay, I ask you just tell me if it is not a sound minded horse, if it is not a healthy horse. Okay, I'm asking you whether this horse A is a healthy horse, white horse is a healthy horse. You are not replying anything. What is understand? Understood as this is a healthy horse. Because if it is not a healthy horse, you might have been conveyed to that to me. See? Now let me read the line. B says to A, what he says, if you do not deny it, what he says, if you do not deny it, I shall assume that the horse is sound minded. A says nothing, which means what? Here, silence is equivalent to speech. Third, half truths. Like it's 50% true or some 40% true, 60% not true, which means what? We have to deliver your content there. If you're not saying the complete truth, then it's not a valid one. So it's a duty to disclose the whole truth. So under 3 points, we can say that silence is fraud. General law is silence is not fraud. See, please make a note here. What the general law says here? Silence is not fraud. Okay, can please make a note here. It's an often repeated question. Silence and fraud. Usually being silent is no fraud. There are three exception cases. First one is a duty to speak. Second one, silence is equivalent to speech. And third one, half truths. Under these three cases, we say that silence is fraud. Okay, yes, please make a note of it. Can you go for this reference heading? A study on fraud and misrepresentation. Please go for a quick glance. Shall I take over? A study on fraud and misrepresentation. When you say fraud, you're wantedly deceiving, which means you have the intention to enter into the contract. Misrepresentation, not such. We have already discussed this. Truth means it's untrue. Here, we believe to be it's a true one. Please make a note of the third one. First 2 points we have already discussed. Make a note of the third one. In case if it is a fraud, you can, what you can do? What do you mean by rescission? Cancel the contract. Rescind the contract means what? Cancel the contract is one of the R term. Okay, revocation, rescission, remission. Okay, so we have so much discussed. And not only that, you can claim damages. Where if you go for misrepresentation, you can cancel and you can get the benefits back. Discover the truth, not such here, but you have to, okay, because only when we discover the truth, you'll come to know it's misrepresentation. If you don't discover the truth, you'll not come to know. You remember that Indigo dye factory. On checking the accounts only, it comes to know that 400 bonds are being prepared. Okay, so if it is not checked, we'll be thinking this is 500 only. Okay, so that's about this one. Shall I go for the next heading? Mistake. This chart is very, very, very important. When we say mistake, we say it's an innocent or anonymous belief about something. Let me go for this chart. Here, mistake can be one mistake of law and another one mistake of fact. When we say mistake of law, we are in our own country, India. If there is any law in India applicable to India, means it's applicable to you. You cannot say, I don't know about this law. Please try to understand, which is ignorance of law is no excuse. You cannot say, oh, இந்த மாதிரி ஒரு act இருக்கா எனக்கு தெரியவே தெரியாது. You cannot escape from that because you are born in India, you are citizen in India, you are a major, it is understood, you know all the law. Even though you don't know anything. What law says, you cannot ignore it. So ignorance of law is no excuse. When you go for mistake of law of foreign country, what happens is if you are uh, going to buy a like chain of shops we have, right, like KFC's, Pizza, Domino's Pizza, okay, or else like what the other one, Tony and Guy, all these shops you have. And if you want to start a franchise, like you are entering into a foreign partner, which means as per the fact, you might be knowing the law of the country. Sometimes you might not be knowing also because it's not your country's law, it is foreign country's law. Okay, let me come again. First category is mistake of law. You have to check whether it's own country law or other country law. If it is own country law, there is no excuse. You cannot say this contract is void, which means the contract will be valid only. Please highlight. If you're sleeping, please wake up from the sleep. It's very, very important. You have to say this is valid. Okay. What happens in the second case? Mistake of law of foreign country. So what happens is if you enter into a foreign partner, you cannot say exactly what is happening. So about the law, you might not be doing, but you have to check with the fact. So it might be valid or it might be void. It depends on because it has to check with the fact. Okay. Because you'll not know foreign law. You know our law. You not know foreign law. Next, we'll go for second heading, mistake of fact. Okay. Main classification. Under that, we can classify as two. One is bilateral mistake and one is unilateral mistake. Bilateral means both the parties' mistake. Okay. Unilateral means any one of the parties. See the term itself, bi, uni. Okay. One party's mistake is unilateral. Both the parties' mistake is bilateral. Under this, we have two subclassification. One is relaying the bilateral mistake, one is relaying with subject matter, and another one, how far this performance is possible to make. There is no existence of the subject matter, or the price of the subject matter is not the same, or quantity is not there. Identity, who is the owner? See, now we are checking about this two pearl necklace example, right? Ownership is not changed means, then how can you say he's the owner and how can you buy the goods? Quality is not the same. Title, who has the right to hold the goods? Title. Under these situation, that is falling under the subject matter, you call this as a bilateral mistake. It becomes void ab initio. Please highlight. It becomes void ab initio. Okay, please highlight. It becomes void ab initio. Which means what? Void from the beginning. You might have entered into a contract that might have entered some 6 months or 1 year or 2 years before. That doesn't matter. If we find out then the subject matter is not valid, then it becomes void from the beginning. Okay. Second, not only that, there should be possibility of performance. Possibility in the sense that not about performing. See, I ask you for 2000 rupees currency note. Will you give it to me? Printing a new one? You can do that action, but it is allowed by law. See, we are not talking about physical possibility alone. Whether we can do it as per the law. So, physical possibility, legal possibility, and also this mathematically possible. Okay. So, all these are based on the possibility of performance. If there is no possibility of performance, then also we call it as void ab initio. Please highlight. It's very, very, very important. Please highlight. Nature of contract. Also, it's void ab initio. Okay. One is You might be inducing another party, not of the fault, but because of mistake, it becomes void ab initio. And because of one party's identity, it might not be in a position to execute. For both the case, we'll go for an example. We just go for the start. So you can just leave the last two. I'll discuss this with an example. Okay. Leave this one and you leave this one. All the earlier parts. Yes, we'll go in detail with respect to bilateral mistake. One point under the subject matter was, so we had 6 points. Remember, under the subject matter, what are the 6 points? Subject, sorry, identity, price, quantity, quality, title. Okay. So one case is identity. X agrees to buy from Y. Please join here. It's very, very important. This last content is very, very important. Y agrees to buy from, sorry, X agrees to buy from Y. What was the agreement? What is the subject matter of the contract? A cargo of cotton is yet to arrive from Surat. Okay, to arrive from Surat. Actually, there are two ships of Y carrying some goods, one sailing in October and the other in December. There are two parties, right? One is X and one is Y. X meant the former ship. Okay, see who's the X here? He's a buyer. What the buyer will think? One ship is coming here in October. That's the very first ship coming here. Okay, so we'll go for that one. But what Y was having in the mind? The later one. There is no clear identity, so the agreement is void. Void or void ab initio? Void ab initio. Why it's mentioned as void then? See, it's mentioned as the agreement is void, which means what? Agreement means void ab initio only, no? So we have void agreement, void contract. When you say void contract, the contract was valid, then subsequently it becomes void, means we'll say it's a void contract. Here the term used is the agreement is void, which means what? It's void ab initio. We're talking on the agreement sense only. We are not going for contract. Okay, please be clear. And one with respect to existence. Second one, second example. X agrees to sell Y some goods on the way from Mumbai and Agra. The truck in which the goods coming caught fire and the goods were destroyed before the day of contract. See, before the day of contract. So it's not in existence at all. Then how can you perform the contract? You cannot perform the contract. Physically not present. Okay. So none of the parties were aware of this mistake. So it becomes a void agreement or void contract. Void contract. Why? Earlier it was there. Now it's not there. So if you come back here, as I was saying, this case it becomes void ab initio. This case also it becomes void ab initio. Yes, it will be void ab initio only. But earlier, while entering, it is valid, and after that, it becomes void ab initio. Means you cannot say void ab initio at that point of time. See, in this second case, what happened? Actually, there was goods coming from Mumbai and Agra, but what happened? The day before the contract only, it got fired and destroyed. So there is no existence. So in this case, you cannot say it's void ab initio. You have to say this is void contract. See, this is how you interpret the case form. Please don't try. See, if this is the heading, void ab initio. If this is the heading, void. No, don't do that way. Law says it's void ab initio, but earlier it was looking like what? Valid contract only, no? Only just the day before of the contract, it got destroyed. Then you cannot say it's void ab initio because it was valid earlier. Now it has become void. But what happened in the first case? One was thinking the former shift, the other was thinking the later shift. There is no consensus addendum. Am I right? What do you mean by consensus addendum? I had two horse. I had white horse to be sold in the mine. You thought it's a black horse. You remember the very first day, first exam we were discussing, instead of two horse, we have two ships here. That's it, only change. There we were saying no consensus addendum, which means no agreement at all, which means void ab initio. Here we are saying no identity. Okay. Yes, pa. Then, with respect to unilateral mistake, one heading is with respect to identity of the party. Can you go for this example, please? This is often repeated example and the only example available under this case. Here is a managing director of a theater. He is giving instructions that no tickets were to sold to S. Okay, so MD gives an instruction to whom? To a person in the sales counter. Okay, that no tickets to be given to S. Yes, knowing this, he asked a friend to buy a ticket. So you go for watching a movie and the theater manager says you're not allowed to watch. Don't give tickets. What you do? எனக்கு தானே டிக்கெட் தர மாட்டேன் என் ஃப்ரெண்டுக்கு தருவல்ல நாங்க படம் பார்ப்போம்ல. This is a situation happening. Yes, knowing this, he asked a friend to buy a ticket for him. With this ticket, S now goes to the theater but was refused admission. உடனே கேஸ் போட்டாரு. தலைவர் கூட ஃபர்ஸ்ட் டே பார்க்கலாம்னா எப்படி? ஓகே, எந்த தலைவரா இருக்கட்டும், நம்ம தலைவர் தலைவர் தானே. ஓகே, he filed a suit for damages for breach of contract. Would he succeed? The answer is no. Why? This is what I call as identity of the party. What was the managing director's instruction? The ticket should not be sold to S. Am I right? Which means what? He should not be allowed to watch the movie in the theater. Please try to understand. This is the way of colloquially introducing the instructions. Colloquially, you discuss like this, right? On a ticket or other. That means what? You should not be allowed to watch the movie. So when he said that don't give the tickets to him, he obviously says he is not allowed to enter into the theater. So when we say identity of the party, see this is falling under which heading? Can you please go through the chart? This is falling under which heading? Identity of the party. Now go through the wordings. Unknown party to the contract. Who's the unknown party? The sales counter person or the friend who got the ticket. Unknown party to the contract cannot give right or no other person can interpose and adopt the contract. The friend cannot come and adopt the contract. Because the friend got the tickets and this person is going inside and buying the watching the movie means is not allowed. This is what you call as identity of the party. This is falling under unilateral mistake. Why it's unilateral mistake? It's not the mistake of the managing director, it's a mistake of the S. It's a beautiful case, Lopa. So identity of the party says that when it is understood as you're not allowed to, no tickets to be given, it's understood as you're not allowed to watch the movie. You're not allowed inside the theater. Okay. Please try to highlight this point. This case, Lindsay case, you can make it later. Nature of contract. The general rule is a person who signs an instrument is bound by its terms. Right? If you are signing an insurance copy, if you are signing an agreement copy, what it is understood as? You have understood all the terms of the contract, all the terms of an agreement, and you have signed it. Okay, so that's what they mean. General rule means this is the nature of the contract. Whatever the nature of the contract is, if your signature is there, it's understood that you have read each and every point and understood in the proper manner. Okay. That's it. For special cases, you can just go to. I have discussed all these things. If any high price, please know the second one. If any high price or high interest rates of increase is not treated as coercion, because Indian Penal Code is not prohibiting it. Please highlight Indian Penal Code is not prohibiting it. Okay. Practical problems. Go for the fourth one, please. L, the owner of gold mine in West Africa sold the mine to M. Okay, so the contract is between L and M. During the preliminary discussion, L has made certain statements about the mine which were incorrect. Though, please highlight this line, though L honestly believed them to be true. Which means what? Is not a fraud. It's a misrepresentation only. After having worked the mine for 6 months, M discovered the true position. What remedies, if any, will M have? Not have any particular remedies under. Only thing he can go is can claim the damages. Okay. It's a beautiful case. It's often repeated case. Lagunas Nitrate Company versus Laguna Syndicate. Then this sixth one actually I'm not going to discuss. I'll just give an highlight. A deceit which does not deceive is not fraud. Often repeated for CMA inter students. For others, you may expect as one line answer. A deceit which does not deceive is not fraud. What do you mean by deceiving means inducing. Okay. So you're making some statement, but your intention is not to induce. Okay. You make some statement not to induce. Induce means what? You are made to attract on something else in that way. It's a fraud. It's not a fraud. Okay. So statement not to induce is not a fraud. You just highlight it. I'm not going in detail. Yeah, I'll go for the ninth one, please. Please send an order for various stationery to his usual supplier. Please highlight this term. B sends an order for various stationery to his usual supplier. Who's the usual supplier? S. Which means what? For many years, S is the supplier and this person B buys from the supplier only. He's a usual supplier. Unknown to B, S sold his business to T. Okay. So now this belongs to T. Now what T does is, because so far S was supplying the stationery, he thought that he can send the stationery to B hereafter. Who? T's thought is this. So T sends the stationery to B. B was not known, right? Unknown to B. B was not known that the business is sold. So B, upon discovering the fact, refuses to accept the stationery. On discovering, he refuses to accept the stationery. You have to advise T. Before going for the answer, please read the question once again. It's a different question. See, if you refer the answer, it will look like very simple, simple one only. Please go through the question and how the situation is created over here. So, who are the two parties? Earlier case, the contracts between B and S were there, but who are the two parties here now? B and T. Who is this T? There is a description given for T that he has got the business from S, the supplier. But this was not known to B. Earlier, S was the supplier and he was the usual supplier for B. So, whenever B places the order or not, each and every month S will is giving the supplies to B. See, each and every month, Singer Academy purchase a lump sum number of papers from a supplier. Okay, usually we get the supply from the supplier called as Murugan supplier. Each and every month for printing purpose. So, without knowing that this person has changed the business, if I receive the order, what happens? He should have told me, right? The Murugan supplier has told me, or either the newly bought person must have told me. Both have not said. Now T sends the stationery to B. Should I accept it? He refuses to accept the stationery. Should I accept it? Need not. Why? There is no contract between B and T at all. There was contract between B and S earlier, and we have clearly mentioned is not known to B, which means what? S did not inform to B, which means what? It clearly, see, this is the point where it clearly says there exists no contract between B and T. See, if you find some 4 or 5 lines, there will be one line or one word or one term which will clearly say this is valid contract or not. Here, this two words, unknown to B, clearly says is not a contract. Because when we talk about contract, there should be one person to offer, one person to accept. See, now go for the answer. T, what's the advice of T? We have to take back the missionary as there is no contract between T and B. See, when you say there is no contract, you have to give the essential which was not sufficient over there. Which means what? B never intended to enter into a contract with T. Now go for the definition of an offer. Very first topic, offer. What do you mean by offer? A proposal, okay, given from one party to another, from one party to another, etc., with a intention to perform it. Which means what? I need to have an intention to enter into a contract. If I'm not having the intention, means how can you say it's a contract? Okay. Probably in later period, probably instead of buying the supplies from S now because S has sold to T, we will be buying from T only. That's different. But what about the current case? It's not a contract. So T has to take back the stationery from. Is it okay? So please make a note of this ninth one. Definitely have to take a keen care. Which line? Unknown to T. Is it okay? So I think that's about free consent. That's it. So in the next class, we'll discuss about lawful object and other cases. Okay. Like 50% contract act we have completed.